Israel, territory, and international law. The subject could not be more topical when we consider the international furore surrounding discussions over proposals to apply Israeli civilian law to areas of disputed territory. But, as is so often the case, it seems, in the context of the Arab-Israeli conflict, accurate legal analysis and appropriate terminology takes a firm backseat to politicized statements, the misrepresentation of international law, diplomatic grandstanding, and point scoring. And on the back of the US peace plan proposals and the Israeli coalition government agreement, the issue is firmly in the spotlight. So to address the application of international law, the realities of the situation, and to take your questions, I'm thrilled to have Professor Bell joining us from Jerusalem. Professor, to start us off, and keeping in mind we have a mixed audience of lawyers and non-lawyers, could you give us your analysis of what international law says about the status of the territory beyond the Green Line?
You've asked a very, very difficult question. I have to say, I teach every year a class on international law and the Arab-Israeli conflict. I spend several of those class meetings discussing this particular question, the legal status of those territories. It's roughly 18 hours of classroom instruction to do the issue justice. And I believe that you're going to give me about 9 minutes. So I will do my very best to give as complete an answer as I can, subject to that limitation. So if you'll allow me to, I'm actually going to try to show some maps here. Are you seeing this? Is it okay? So very good. And my apologies to all the various places from which I have borrowed, I hope in fair use, their copyrighted works. When we're talking about the legal status of the territory of what most of the world calls the West Bank, and I think that's what we're talking about today, we're talking about a very tiny piece of territory. You can see over here a map that I borrowed from BICOM that shows a comparison of the state of Israel, inclusive the Gaza Strip, West Bank, and Golan Heights, compared to England, Scotland, and Wales. And as you can see, we are not talking about a very large piece of territory. The West Bank is what looks like a face with an open mouth of some kind, in the darker blue of the state of Israel. It's not a very large piece of territory. But as Natasha, as you said, this tends to be an issue where there's an inverse proportion between light and heat. And there's a lot of heat, and so not much light. Now, to understand the legal status of the territory forces us to actually take a step back in history. The last point in time where everyone agreed about the legal status of the territory, about who had sovereignty, is 100 years ago, when it was more than 100 years ago, when it was controlled by the Ottoman Empire. As you can see, the Ottoman Empire then controlled a substantial chunk of the Middle East. It lost control of that territory during World War I. And what the victors did, Britain and France in particular, they divided up this territory not as parts of their empire, but they created, together with the other allied nations, an entirely new form of legal organization of territory. It was called a mandate. And they divided up the territory primarily into 3 mandates. 2 went to the state of Britain, Palestine, and Mesopotamia. And the 3rd, Syria, went to France. Now, this was an entirely new form of legal organization of territory. And so it's unclear even today what the legal implications of it. And this is part of the start of the legal dispute about the land. It is the West Bank, you can see, is a little portion of what was the mandate of Palestine. It would probably be under 8% of the total territory of the mandate of Palestine. And what this meant, it was not at all clear. Now, I will say that there was one piece of the mandate for Palestine that was special, and it does play a role in understanding the legal situation, and that is that the mandate was issued by the Allied States and approved by the League of Nations after Britain had issued the Balfour Declaration, favoring the reestablishment of the Jewish homeland in Palestine. And that Balfour Declaration was incorporated within the mandate. It was within the terms of the mandate as they were approved first by the Allied nations in San Remo in 1920, and then thereafter as they were approved by the League of Nations in 1922. And they very clearly charged Britain with reestablishing the ancient Jewish homeland in the state of Palestine. There was only one exception to this. The Brits were permitted to exclude from the Jewish national home the Transjordanian parts of the mandate. That would be what today we know as the state of Jordan. But there was no such restriction to the eastern part, sorry, to the western part of the mandate. That is what we would call today Israel, Palestine, the Holy Land. Here we get into very problematic terminology. Now, the mandate for Palestine was functionally divided for most of its history between the Transjordanian part and the Cisjordanian part, the western part, which was the part designated for the Jewish homeland. And it was actually legally divided in 1946 when Britain recognized the independence of a state of Transjordan east of the river. And that meant that in 1948, the mandate of Palestine looked like this. It incorporated all of what today we refer to separately as the Gaza Strip and the West Bank, or as it was referred to then, Judea and Samaria. And there was no distinction within the mandate among those territories. Britain, as the 40s went on after World War II, got in increasing trouble over the mandate, primarily because the British were refusing to admit Jewish immigrants, even though they were required to do so by the terms of the mandate. And they were refusing to do so even after it became clear that, that Nazi Germany had murdered 3/4 of the Jewish population of Europe, and Britain was refusing to admit the refugees. In 1948, Britain, after consulting with the United Nations, getting a recommendation and refusing to implement it, Britain simply walked away. That was the last legal boundary that was established for this territory. Following the war, there were ceasefire agreements. When Britain left, the Arabs invaded Transjordan, Lebanon, Syria, Egypt, Iraq, and Saudi Arabia all invaded and grabbed what they could grab from the territory. There was a second war in 1956 and a third war in 1967. In 1967, Israel managed to push back the invaders from 1948 and beyond. And so Israel not only took back Judea and Samaria, which Transjordan had since renamed the West Bank, and along with renaming itself from Transjordan to Jordan, Israel also managed to capture Egyptian territory, the Sinai Peninsula, and Syrian territory, the Golan Heights. But all these were simply ceasefire agreements. These were captured. It was captured by Jordan, captured by Egypt, and then captured by Israel without anyone agreeing to a transfer of sovereignty. Now, more recently, Israel reached a series of agreements with the PLO during the 1990s to divide up administrative control of the West Bank and Gaza and create a new Palestinian Authority that would control the affairs of Palestinians in that area. They agreed that part of the land, what we would call today parts A and B, or areas A and B of the West Bank, would be under the territorial control of the PLO, whereas the rest of it, Area C, which is the blue portion here, and roughly 60% of the West Bank, would be under Israeli territorial control. But the PLO Israel agreements said explicitly that they did not address issues of ultimate sovereignty, that was left open for final status negotiations between the party, and in the meantime, everybody preserved their positions. So we have a history going back to 100 years. We have an agreement that the Ottoman Empire had sovereignty during World War I, and we know that mandates were created from it since then. And after the end of the mandate in 1948, we have no agreement. There were wars, possession over the territory changed hands without a solid agreement as to sovereignty over the West Bank. So whose is it? And here, if you'll excuse me, I'm going to use this slide even though it's not a map. Here are the possibilities. The general doctrine by which international law determines who has sovereignty over territory when a new state is formed, or in particular when a new state is formed out of former colonial possessions, including mandates. The general rule is what the Latin phrase is uti possidetis juris, but the rule is that the new state incorporates all of the territory of the previous administrative unit. This is, for example, why most states in the world believe that the Ukraine still has sovereignty over the Crimea, even though Russia captured possession in a very brief conflict. And that's because that territory, Crimea, was part of the Ukrainian Soviet Socialist Republic at the moment when the Ukraine became an independent state. And so the Ukraine succeeded to the entirety of the legal territory of that administrative unit of the Soviet Union. And if that's the rule that we use, and that is the rule that's used elsewhere in the world, then it's fairly clear that since 1948, Israel has had territorial sovereignty over all of the mandate of Palestine, including the West Bank, including East Jerusalem, and including the Gaza Strip. Now, there's another argument that can be raised regarding the territory, which is, well, maybe we should set aside the general rule of uti possidetis juris and respect the rights of self-determination of the peoples involved. Now, there are two peoples involved here, the Palestinian people and the Jewish people. The Palestinians often claim title on the basis of their right to self-determination. That's not generally the way these things work in international law. In international law, uti possidetis juris is generally seen to trump self-determination, but the Palestinians nevertheless claim title on the basis of self-determination. There's an interesting flaw with this argument, which is the mandate over Palestine specifically gave rights to the Jewish people to reconstitute their ancient homeland. And in general, it's understood that mandates were vindications of the rights of self-determination of specific peoples, which means that as strong as the Palestinian right of self-determination is, there's a prior right of self-determination of the Jewish people, which was endorsed in the mandate for Palestine and then given continued force after the mandate by Article 80 of the UN Charter. Now, there's a third argument that's often raised regarding this territory, which is that it's not acceptable these days, or at least most legal academics and scholars and practitioners believe that these days military conquest does not give states title to land. Now, this is an argument that's often used regarding Israel and the West Bank. It's claimed that Israel can't claim title by virtue of its conquest in 1967. And I suppose that's fair enough, although it's also true that neither Jordan nor the Palestinians can claim title by virtue of Jordan's conquest in 1948. If we throw out the conquest, we're left once again with the situation as it was in 1948, and that is that Israel succeeded to title to sovereignty by virtue of the doctrine of uti possidetis juris. Now, it's a possible argument that one of the other sides has acquiesced or abandoned its claim. Perhaps Israel gave up its claim. But if you look through the agreements, you'll see that Israel has never done so. It's possible to get to an agreement to change the borders, but if you look through the chain of agreements, Israel has a border agreement with Jordan. It has a border agreement with Egypt, but the border agreement with Jordan does not address the question of sovereignty in the West Bank, and Israel's agreement with the PLO likewise does not address it. Israel and the PLO may reach an agreement in the future, but at least to date, there hasn't been a change of sovereignty. And of course, then you have the last argument. The argument is not really one of international law, but it's the one that's most popularly raised. It's often said that the international community has decided that the West Bank is occupied Palestinian territory, or that it's sovereign territory of the state of Palestine. And it may very well be true. I haven't seen polls on the subject, but I presume, based on what I see in the media, that most of the international community, which I presume means most of Europe, believes that the Palestinians have sovereignty, or the right to sovereignty, over the West Bank. Now, that's a very interesting point. It's not a point of international law. International law does not recognize awarding title by popularity contest. So if you look through these factors, I think that it's fairly clear that under international law, Israel has title. It's title that Israel can agree to surrender, and Israel's negotiated over in the past and may yet agree to surrender in the future. But until that changes, it seems to me fairly clear that Israel has sovereign title under international law over the disputed West Bank and East Jerusalem.
Well, Professor Bell, thank you so much for starting us off. We've had questions flooding in already, and happily your explanation has actually already answered a number of those. Before we turn to the additional questions, perhaps we could look for a moment at terminology and deal with the charge of annexation. Even if we say that there's a debate about underlying Israeli sovereignty, the concept of annexation still appears wholly inapplicable to the situation. I've looked at two definitions, first from the ICRC, the International Committee of the Red Cross casebook, a unilateral act of a state through which it proclaims its sovereignty over the territory of another state, and also from the Encyclopedia of Public International Law published by Oxford University Press. Annexation means the forcible acquisition of territory by one state at the expense of another. Now, the fact remains that Area C is not part of any other state. There is no acquisition from another state in that sense. It's not clear how any of these definitions of annexation could be argued to apply, is it?
Yes, I think you're absolutely right. What's raised the debate in the past few months has been a proposal, a political program that's been announced by the Prime Minister of Israel several times to apply Israeli civilian law and jurisdiction to parts of the West Bank. It would be parts of Area C. What parts exactly, we don't yet know. We haven't seen the map. But that's the proposal that the Prime Minister has raised. When he's spoken about it, like many Israelis, he's spoken about the application of Israeli sovereignty. What he means by that, what Israelis mean by that, is not acquiring territorial sovereignty that Israel already has. What they mean is sovereignty in the sense of exercising authority. And they mean Israel would be exercising its authority through its laws over those territories. Now, opponents of this move describe it as annexation. And when they say that, they're assuming something which is wrong. They're assuming that Israel lacks a claim of sovereignty to that territory. They're assuming that another state actually holds sovereignty to that territory, and that when Israel applies its laws, it will be taking some other state's territory. Now, that's not what's happening. It's unfortunate that terminology like annexation is used by people who should know better. The fact that it's used in popular discussions in the media is more excusable. It's simply a shorthand, and as we know in media discussions, sometimes you have to use shorthands.
Well, you've explained in your presentation the parallels with Ukraine and Crimea. We've had a question pertaining to Russia's annexation of Crimea. There are some who are calling for sanctions on Israel by drawing parallels with the sanctions imposed on Russia for its annexation of Crimea. That's, of course, the direct inverse of the parallel that you described. Can you comment at all at how widespread that particular misrepresentation might be becoming?
I think that's exactly right. If you apply the rules consistently of territorial sovereignty and uti possidetis juris, you should look at Israel's claim to the West Bank as similar to the Ukraine's claim over Crimea. It makes no difference in the case of the Ukraine that a majority of the population in Crimea is of Russian ethnicity, and therefore is amenable to the Russian takeover. The rule still is in the Ukraine, and the rule is in the case of Israel, that uti possidetis juris establishes the boundaries of new states, and they can be changed thereafter by agreement, but pending such agreement, they stay the borders. Now, why then is it that countries are nevertheless calling to punish Israel for acting according to international law, exercising rights that it has? I think that you'll have to look somewhere other than international law. I think it's not a question of international law, it's a question of international politics. And as we know, there is one Jewish state in the world, and it is not very popular politically. I think it's also true that the rhetoric of international law is sufficiently obscure to most people that when critics of Israel want to apply a double standard, it's easy for them to pretend the law permits it. But the law does not. This is not a matter of international law to call for sanctions of Israel, against Israel. It's a matter of a singular adverse standard for the Jewish state.
Well, moving on to that international reception for a moment, of course, it's not just referred to as illegal annexation in the press, as you indicated, but frequently we hear the proposals being referred to as illegal UN resolutions. We had a statement from UK Ambassador Jonathan Allen to the Security Council last week, a statement from the EU the week before. Now, I appreciate these are political statements, they don't have legal impact, but do you have any insight or theory why there is so much misstatement on international law here? And following that, a question we've just had in, what impact would annexation have on international relations going forward, including with Europe, do you think?
I can only address the first question very briefly, and that's because I can't really read the minds of people who distort international law. I can only observe that they are distorting it. So why it is that they want to distort the international law in order to create a uniquely adverse standard solely for the Jewish state, I can speculate. I imagine that you can speculate as well as I can, and you would probably reach similar conclusions. That said, I prefer to stick with what I know. I don't know what's going on in their minds. I do know that what they're saying is incompatible with international law as it is understood everywhere else in the world. Now, what are the likely consequences of this? I think that most of Europe, and it's not all of Europe, but most of Europe has been following a multi-year program of imposing certain kinds of diplomatic and economic sanctions against Israel, often with the excuse of international law rhetoric, generally related to an attempt to vindicate Palestinian maximalist territorial claims to all of the West Bank, East Jerusalem, and the Gaza Strip without having to soil themselves with actually negotiating an agreement with Israel. And I expect that's going to continue. There is going to continue to be these low-level diplomatic and economic sanctions. There will continue to be statements condemning Israel. There will continue to be discrimination in international trade against Israeli products from areas that the Palestinian claim, and the like. Will they be ratcheted up? I think that we're simply going to see the continuation of the European program, which was enunciated in a variety of different places a number of years ago, and it will continue to be carried on. So we're going to see more of the same kinds of diplomatic and economic sanctions. We will see more cooperation with the distortions of international law that you're seeing at the UN and the International Criminal Court and the like. I don't think this is going to change anything fundamentally, because the EU's position has been for a number of years that simply permitting Jews to live in the West Bank is itself an act of illegal annexation. In fact, you'll see that in various statements that have been put out by the External Action Service. So I can't think that it'll be a difference in kind, not even a very large difference in degree. It'll be a continuation of the same.
So staying with that potential impact for a moment and looking specifically to the region, in particular the response of the Arab and Muslim world. We've had the King of Jordan, King Hussein, issuing a statement, also Erdogan yesterday. Could you say a few words about the position of the Palestinian leadership? Clearly the security cooperation has been a real talking point. Today reports that the army liaison to the Palestinians has warned the IDF Chief of Staff Aviv Kochavi and Defense Minister Benny Gantz of a potential wave of terror. Now, I appreciate that in part will concern a potential increase in Hamas activity, and no doubt that threatens Abu Mazen and his Fatah colleagues significantly. But what do you make of all the warnings for Israel, both very close to home in terms of Hamas and the West Bank, but also in terms of the region more broadly?
Well, the Palestinian position has always been Hamas explicitly, Fatah is sort of more ambiguously, but has always been that the Jewish state is itself illegitimate, and so any Israeli law applied to Ma'ale Adumim, which is a suburb in the West Bank of Jerusalem, is just as illegitimate as Israeli law in Tel Aviv. They're all illegitimate. Israel is simply an occupier, and so as a matter of ideology, the opposition is the same. As a matter of rhetoric, it turns out the opposition is the same. This week, the head of the Palestinian Authority, Mahmoud Abbas, announced that he was canceling the agreements with Israel, but then he announced the same thing a year ago, and 3 years ago, and 5 years ago. And as it turns out, there isn't very much to cancel, because the Palestinian Authority has been systematically violating those agreements almost from the moment they were signed, in particular with its continued support of terrorism. So it's hard to see that there will be a concrete change there. The one thing that is discussed that's worth speaking about is that for the past roughly decade, the Palestinian Authority, which is dominated by Fatah, has been cooperating with Israel in combating Hamas on the West Bank. Now, this is not a matter of a change in ideology. This is a matter of self-preservation. The Palestinian Authority saw how it was pushed out of the Gaza Strip. It does not want to be similarly pushed out of the West Bank. And so it's, as a matter of prudence, rather than a matter of ideology, cooperated with Israel in fighting Hamas. And notwithstanding this very public announcement of an end to security cooperation, that interest remains the same. The Palestinian Authority is not interested in being deposed by Hamas, and it will take Israel's help in fending off the challenge from Hamas as long as it can. And I think that's what's actually going on the ground today. I don't imagine there will be any change until there's a change in interest in the Palestinian Authority.
And that might best be summed up by Abu Mazen indicating he, on behalf of the Palestinians, or they could wait 100 years. before embarking on those negotiations. We've had a question as to whether you think the proposed annexation of significant parts of the West Bank by Israel's new government, I suppose we've already dealt with the issues of terminology there, but whether that move will promote or prevent any enduring peace with the Palestinians. Do you believe that moves like this might actually prompt negotiations in the future? It does seem that there is a hope within the Trump peace plan that might in fact be the mechanism for driving things forward.
Well, it's been fairly clear for the last several decades that the approach of endless indulgence of Palestinian maximalism has not gone very far. So more or less the European approach to the negotiations since their onset has been to endorse every Palestinian claim, to back every Palestinian demand, no matter how unreasonable, to take every offer that Israel makes and to which the Palestinians refuse as the baseline for the next Israeli offer, which has to be more generous than the previous one, and to think that this is going to get negotiations going. And it hasn't worked at all. At this point, not only the Palestinians, not only has Abbas announced that there's not going to be any concession on any point by the Palestinians. They made their last concession by agreeing to speak with Israel about the West Bank, Gaza Strip, and East Jerusalem in 1993. It's also clear they're not even going to walk into negotiations without getting paid off. That's what their position is. Now, how does applying Israeli law to part of this territory affect that? In one sense, it doesn't affect it at all. Israel is able to negotiate over territory to which its law applies, and it has in the past. Israel negotiated with Syria over the Golan Heights. It's negotiated with the Palestinians over parts of Jerusalem where Israeli law applies. It doesn't change the parameters or the ability of the parties to negotiate. So in that sense, it has no effect. But there is a sense in which it has a good effect. If to the extent that the Palestinians believe that this is a step that's going to help Israel, that is something that the Palestinian Authority opposes. And that's a loss that the Palestinian Authority will feel as a result of its intransigence. And that's a good thing. That may be something that will encourage them to drop the no negotiation stance, to drop their intransigence about any concessions, and consider coming into negotiations before they lose more.
And of course, on that point, I think it's worth emphasizing that none of this really prejudices any final settlement or what it would look like. All proposals around a two-state solution have envisaged sovereign Israeli territory being transferred in the context of land swaps. And in fact, most recently, the Trump plan proposals include significant chunks of the Negev being likewise transferred in that fashion. Pausing just on the international arena, and we'll come back to it because we've got some more questions on that. Just for a moment, taking a look at the area that is subject to these proposals. These are, of course, areas under Israeli civil jurisdiction already, formalized under the Oslo Accords. We've had a question regarding the effect of what the proposals on the Oslo Accords would be. Could you elucidate what effect that might be?
Certainly. Okay, so one thing to understand is that the Oslo Accords actually don't address the substantive Israeli law to be applied in Area C. Area C, as I said, is, and as you said just now, it's the area in the West Bank where, under the Oslo Accords, Israel maintained territorial jurisdiction, and Israel would continue, therefore, to apply a set of its laws. But since 1967, Israel has not applied the civilian law of the rest of the country in the West Bank. What it's applied instead is a mishmash of military orders, Jordanian law as it existed until 1967, mandatory law as it existed, as it was preserved by the Jordanians, Ottoman law as it was preserved by the Jordanians, and it's a real legal mess. Among other things, there's some bizarre features, but here's probably the most bizarre one. Under Jordanian law, it's unlawful for Jews to buy land in a private land transaction. And therefore, the only way that Jews can buy land in the private market in Area C is to create straw man companies, fake companies that are going to do the purchasing for them, and then they have to get administrative approval. It's a very bizarre system. There's no centralized registry. It's not a very good way to run any system. And so what Israel is talking about doing is replacing all of that with the Israeli civilian law, which would mean that Israeli land law would apply, and Israeli land use law would apply, and Israeli criminal law would apply, and the rest of it. And that would mean that all the residents of that area, be they Jewish or Palestinian, would function and benefit from the same set of civilian laws that the rest of Israel benefits from, including, by the way, welfare benefits, which all of the Palestinian residents of the area would then be eligible to get. Now, what does that have to do with the Oslo Accords? Well, nothing, because the Oslo Accords did not bind Israel to govern its section of Area C in any particular way. The objection that is raised against the Israeli move is that in doing so, Israel would be, in applying its law, Israel would be, quote, changing the status of the territory. Now, I think I've already said I don't think that that's the case at all. I think that presumes something that's incorrect, that Israel is trying to annex or acquire rights it doesn't have. I think that Israel already has these rights. It's not trying to add to them in any way. It's simply exercising its governing rights in a different way. And it's particularly ironic because the Palestinians have tried very hard to violate that clause multiple times. And so the Palestinians have held themselves forth as a state, changing their status under the Oslo Accords, contrary to their agreements. They've joined international treaties contrary to their agreements. They've just recently, just in the last year, have announced that they no longer recognize the division of the West Bank between A, B, and C, and will try to exercise their authority in Area C, which is, again, that is clearly trying to change the status. And so I think that it's very hard to argue that Israel is violating the agreements. It's very easy to see that the Palestinians are and have violated the agreements. And this gets us to the last irony. Here we have the Palestinian Authority announcing for the umpteenth time in the last few years that it no longer follows the Oslo agreements and does not respect them. And then people are turning around and saying, Israel, why aren't you following them?
Well, a moment ago, you were answering the next question, which is what are the advantages of extending Israeli civilian law to parts of the West Bank, Judea, and Samaria? Professor, I know that there are some environmental lawyers in the audience. So could you speak also to the impact that the application of civilian law would have for proper enforcement of environmental regulation in the area? In the last week, there have been worrying reports from NGOs about the illegal dumping of waste by the Palestinian Authority in Area C. One site in the Binyamin area with an estimated 10,000 cubic meters of waste which has been dumped while authorities have been consumed with the COVID-19 response. At the moment, of course, you've described part of the challenges that we have a patchwork of applicable law and inconsistencies. So what effect would the proposals have on issues to do with, say, environmental regulation?
Well, it would have a very dramatic effect on environmental regulation because right now there is no environmental law in the West Bank. Or if, to the degree that there is, it's a few bits of leftover Jordanian legislation from the 1960s and a few military orders. Now, if you know the history of environmental laws, there was no Clean Air Act in 1967. Almost all of the Israeli legislation for environmental law was post-1967 and never applied, therefore, to the West Bank. So clean air, clean water, solid waste disposal, almost any subject that you can think of. The West Bank is the Wild West. There is no regulation of air pollution or of sound pollution or of water pollution. and as you mentioned, it's even basic things like solid waste disposal is basically done outside of any legal framework whatsoever. So the result of applying Israeli civilian law would be not just an improvement in the legal rights of all the residents, Jews and Palestinians, it would introduce for the first time a number of subjects for which there is a desperate need for legal protection, such as protecting the
and
environment.
following on from that, questions regarding the impact on the Israeli civilians living there and the impact on any Palestinians that would be living in those specific areas.
Yeah, so Israel, this is not the first time that Israel is talking about applying parts of applying its civilian law to different territories. So, as you know, parts of Jerusalem, what we call East Jerusalem, was parts were under a Jordanian occupation from 1948 to 1967. And when Israel captured those areas in 1967, one of the first things that it did was that it applied its civilian law to East Jerusalem. That is, it incorporated those traditionally those parts that were traditionally part of the city into the Israeli civilian legal framework. Now, what was the result of that? So one of the things was that the Jordanian residents of the city, there were no Jewish residents of East Jerusalem because Jordan had expelled all the Jews from its territory. The Jordanian residents now had access to Israeli healthcare. And for example, that means that they can demand the right to join the National Health Service. It's not quite like the British version, but it has a fairly good protection for the health of all of the residents, not necessarily citizens, meaning the Jordanians who were living in Jerusalem did not have to acquire Israeli citizenship in order to enjoy the benefits of Social Security and health care and the like. Now that's the model, and that's the model that we're talking about here. As a result of automatically becoming residents, they will have the right, everyone who is not a citizen will have a right to apply for and acquire citizenship under whatever procedures the Ministry of Interior determines. They have been fairly non-demanding to date, and I have to imagine that will continue to be the case in the future. And so what you will have is that Palestinian population, which will find itself now under Israeli law, and it won't be a very large one because Area C was designed not to include the Palestinian population. Area C was designed to be the areas outside of where Palestinians live. The idea was in the Oslo Accords was to give the Palestinian Authority control over almost all of the Palestinian population. But those Palestinians who do live in Area C, in those parts where Israeli law applies, will become Israeli residents entitled to all the benefits of the law and also have the right to apply for and receive Israeli citizenship should they choose to do so.
Well, you're answering the questions as in fact they're coming in. We'll pivot topic somewhat because we've had a question with respect to the concept of sovereignty in abeyance. Certainly it's formed part of the prosecutor of the ICC's recent response to amicus curiae briefs that have been submitted. Perhaps you could talk about, I appreciate we're running low on time, but briefly address that concept and also to what extent this topic will prove a significant one as part of the ICC's investigation.
Yes, well, for those who don't know, and I presume that the non-lawyers in particular will not know, the International Criminal Court is an international court that has limited jurisdiction. It's not supposed to hear cases about any potential criminal in the world. It's a court whose jurisdiction is limited to defendants that are either citizens of parties that have submitted themselves to the jurisdiction of the court, or defendants who carried out alleged crimes in territory of a state that submitted itself to the jurisdiction of the court. Now, Israel is not a part of the International Criminal Court and is unlikely ever to be. Israel correctly views the court as political and biased, and understands that it is not a wise idea to submit itself to the so-called justice of that kangaroo court. That said, for the same reason, the Palestinian Authority has been very eager to join up with the court because it expects that the court will dispense political justice, that is, it will go after Israelis. And the Palestinian Authority has been working with the court now for 11 years, trying to move forward cases against Israelis. And in order to do so, it has to argue that the Israelis are committing alleged crimes on the territory of the state of Palestine. Now, this is a problem because A, there is no state of Palestine under international law, and B, in no small part because there is no state, there is no territory of the state of Palestine. Now, the prosecutor has tried to bring the charges against Israelis, or build up a case for bringing charges against Israelis, despite these huge flaws in the case. And she's asked a pretrial chamber of the International Criminal Court to approve her theory that there is a state of Palestine, even though there isn't one under international law. There's enough of a state of Palestine under court procedural rules for them to accept the jurisdiction of the court, and for them to approve her theory that even though this non-state doesn't have any territory, the Palestinians have territorial sovereignty as a people, and this territorial sovereignty can be exercised by the fictional state of Palestine. It's not a very coherent theory, but one of the arguments that the prosecutors tried to pass through is that it doesn't really make a difference what the status of the territory is, and so therefore she's offered a lot of incompatible arguments. And one of them addresses a claim that Israel makes. Israel says, look, even if you don't accept our claim to sovereignty to the territory, it's certainly not territory of another state. If anything, then the sovereignty is an abeyance. It's sovereignty held by no state. And the prosecutor's response to that was, no, it's not possible for sovereignty to be an abeyance. It has to be held by a state, and therefore it is held by the state of Palestine, even though the state of Palestine is not exactly a state. Right? This is not a model of logical consistency, but don't expect any from the International Criminal Court. We're on a ride towards criminal charges against Israelis for non-crimes, and the fact that the court lacks jurisdiction, this is not in the territory of a non-existent state, doesn't really make a difference. And Natasha, I believe you've muted yourself.
My apologies, jumping in too soon. To go back to really the topic of your original opening presentation, a question here: successive Israeli governments have described the territories as disputed, not occupied. How is it possible to assert sovereignty unilaterally? And connected to that, could you perhaps also answer the question as to whether there are any countries to which uti possidetis iuris has not been applied since 1920?
Okay, so let's start with the first one of these. Israel describes the territories as disputed, not occupied. What does that say about Israel's position? So I think it's fairly clear what it says about Israel's position. The Israeli position is it's disputed between Israel and the Palestinians. The Palestinians claim it is theirs. Israel disputes that claim and claims what? I think it's fairly clear what the other side of that dispute is. It's also clear why Israeli officials prefer not to press the point and prefer instead to describe it as disputed. The ideal resolution of this for Israel, for the dispute about sovereignty, is not for Israel to unilaterally dispose of all the claims, but rather to do this by agreement. And so I think that you're going to continue seeing that in the future. Part of the current plan, in addition to applying Israeli law, is for Israel to accept negotiations based on the Trump peace proposal. The Trump peace proposal calls for Israel, in the framework of an agreement to which both sides agree, to yield territory to which Israeli law applies. And so Israel clearly does not see the application of Israeli law as the final word on this. The final word ultimately will be an agreement when the Palestinians decide that they're ready to talk. I don't think that we're near to that at the moment. Now, the second part of your question, I believe, related to the use of uti possidetis juris. Has it been used everywhere? The answer is both yes and no, and I'll tell you why the answer is both yes and no. Uti possidetis juris is a default rule. It's a rule for determining the boundaries of new states where there hasn't been an agreement. Well, a lot of new states created their border by agreement. The Czech Republic and Slovakia agreed how to split up. Now, as it turns out, they agreed to use the administrative lines as the boundaries of the new state. But they don't have to, and there have been cases where there's been agreement simply to do things a different way. Israel created its border with Jordan by agreement. It says in the peace treaty, it's with reference to the British boundary, but the actual boundary is the one that's drawn on the attached map. Now, why would Israel do that? It was not to reject uti possidetis juris. It was to make sure that afterwards the lines were perfectly clear. And so there have been cases where states have agreed to different lines, but I can't think of a single case in the last few years in which there's been a boundary dispute in which a claim of uti possidetis juris was out there, that the court said it cannot be applied to this situation. On the contrary, the court has rejected, the International Court of Justice and other courts have rejected the idea that uti possidetis juris is a special rule for special occasions. In the case of Burkina Faso versus Mali, the International Court of Justice said, no, it's a universal rule, applies everywhere. It's been applied in Asia, it's been applied in Europe, it's been applied in Africa, it's been applied in Latin America. It's hard to think of any reason it would not apply here.
And also just considering that Burkina Faso Mali case, the court seized upon the opportunity really to go into the principle in detail and describe that the purpose of the doctrine is to prevent independence and stability of new states being endangered by what it called fratricidal struggles provoked by the challenging of frontiers following the withdrawal of the administering power.
Right.
I mean, that set of circumstances would seem to apply
It says very clearly the purpose of uti possidetis juris is clear lines, even at the expense of justice, right? Even at the expense of self-determination. It says it talks about the problems of borders in Africa. It says the borders in Africa represent colonial judgment that were often quite unfair to the local people. There have been border disputes going on for many, many years, and it is not possible, said the court, to try to come up with a rule that makes clean lines and that also accommodates all the conflicting claims of justice of the parties. That's why we have a rule of uti possidetis juris, clean lines. I think it's precisely applicable to the case here.
And just on Israel's own position, I think it's perhaps also worth noting in July 1967, then Minister of Foreign Affairs Abba Eban informed the UN Secretary General in writing that its acts with respect to Jerusalem, so the application of Israeli law in full to Jerusalem, he wrote that did not constitute annexation. It would follow perhaps that a similar act in the coming months would also officially then not in the view of the government of Israel, constitute annexation. We are fast approaching the end. We have had so many questions. It's been impossible to deal with all of them, but I hope that we've taken a good spectrum. Perhaps we can conclude with this final question. And I don't know if you have been following from Israel the incredible chasm that seems to have opened up in the Jewish community in the diaspora over the proposed Israeli action. We've had a few questions arising from that. Certain community organizations are campaigning pretty fiercely on this issue. Is that resonating in Israel, where the public polls would indicate that in fact the majority support such a move?
I think that in general, in issues that Israelis view as concerning their own security and future, Israelis tend to think that the opinions that count are the ones of those whose lives are on the line, and I think that's the same thing here. There's always a very delicate and important balance in Israel. It's very important in the Jewish state to take account of the opinion and needs of Jews around the world. And I don't think that's going to change, but I also think that it's going to continue being the case that every matter of life and death in Israel will be decided by Israelis.
Well, I just, in conclusion, want to thank Whose Land for supporting this discussion, all of the attendees, of course, for joining and submitting these great questions, and to Professor Bell, thank you. I hope that your insight, your analysis, your explanation will give those listening and watching the tools to, and also the confidence to challenge the misrepresentation of international law, to challenge the bogus assertions that Israel acts in violation of the law, and really to call for an end to these smears. So until next time, shalom.
Thank you, and thank all of you.